I'd like to welcome everyone today to the Munk Center for International Studies, University of Toronto. My name is Professor Gregory Chin. It is my honor and pleasure today to introduce Mr. Alan Hu. Mr. Hu is going to speak to us today about the Joint Declaration, Basic Policy, and the Basic Law. In a second, I'm going to introduce Alan Hu. I'd also like to thank the Rotman School of Management and the Hong Kong Canada Business Association for co-sponsoring this event. Mr. Alan Hu graduated from the London School of Economics and Political Science at the University of London with a Bachelor of Laws. He was called to the UK Bar at Middle Temple in 1973 and was admitted to the Hong Kong Bar in 1975. This was only the beginning of his many accomplishments. He was appointed as Queen's Counsel in 1990. He sat as Deputy High Court Judge in 1992 and 1993. He was a member of the Bar Council of the Hong Kong Bar Association from 1986 to 92 and was Chairman of the Special Committee on the Liberalization of Legal Services Market in the mainland China from 1990 to 2001. Mr. Hu was appointed as the Justice of Peace in 2002 and awarded the Silver Brahiniya Star in 2004. He is presently the chairman of the Basic Law Institute, which has established a basic law library in collaboration with the Hong Kong Special Administrative Region Government. He is also serving on the Basic Law Promotion Steering Committee and the Commission on Strategic Development. He is currently the chairman of the Educational Appeal Board, the Pharmacy and Poisons Appeal Tribunal, and the Capital Adequacy Review Tribunal, to name a few of Mr. Hu's achievements. Today, Mr. Hu will be speaking to us about the Joint Declaration, Basic Policy, and the Basic Law. I just want to say one thing very briefly and then hand over the floor to Mr. Hu, who's a real expert. The Basic Law is important as it enshrines certain general principles that are the key to the continuous success of Hong Kong as an international business and financial center, a link for China to reach out to the world. So it is my pleasure today and honor to invite Mr. Hu to come and give us a presentation. Thank you.
Good evening. I should start by explaining why I'm in North America to give this talk to you today, and why particularly at this moment. This is the 10th anniversary of the handover of Hong Kong to the PRC. That, as you all know, took place on the 1st of July, 1997. And the subject of today's talk concerns the Joint Declaration, basic policies, and the basic law. I don't know how many of you keep up with events in Hong Kong, or in Macau, or even Taiwan. And why do I mention these three places? What do they have in common? All these three places are part of China, which they have lost exercise of sovereignty over the last 1.5 centuries for different reasons at different times. The first relevant date to remember at this anniversary year is 1842. 1842 is the date of the Treaty of Nanjing. That is the date when Hong Kong Island was taken by the British by force, and the treaty subsequently imposed upon the Manchu government. Then you had the Treaty of Beijing that led to Kowloon being taken, and then there was the lease of the rest of Kowloon and the new territories for 99 years. So that's a relevant date because 99 years, why 1997? Because 99 years before that, there was a lease. And the lease affected the legitimacy of the major asset of the Hong Kong government. It started really, the problem started by businessmen in Hong Kong, not by government officials, not by scholars, not by politicians, but the whole problem was first initiated by the business community in Hong Kong, particularly real estate developers. Crown land is the main asset of the Hong Kong government. Literally, they sell bits of it every year, and just from the land sales, it covers over 51 to 2% of government expenditure for the whole year. But that golden structure that the government can fall back on at all times, that structure that allowed the Hong Kong dollar to be pegged to the US dollar at a fixed rate, i.e. without bending to market forces, it's a permanent peg. Very unusual, a political peg. You need to have very strong resources to be able to say that. And that golden structure was immediately affected when the lease or the expiration date draws near, because you don't have to get right up to 97, because you have to grant leases when they end for, let's say, if a lease ends in 1970, a Crown lease. You have to renew it for 25 years, 50 years, depending on the nature of that lease. You can't, because the very legality of the occupation of Hong Kong by the British government depended on the validity of that treaty being respected. And that treaty has a sell-by date, 1st of July 1997. So then Lord MacLehose, as he now, or as he finally was, he was then governor, and he informed the Foreign Office that we now have a problem about Crown leases and the renewal of that and the subsequent consequences. Then the next relevant date, jumping a century, is 1982. Why is that a relevant date? That is the year that Britain went to war in the Atlantic against Argentina over a colony called the Falkland Islands. The Falkland Islands is aptly described as very much a God-forsaken place, somewhere near the Antarctic, with 2,500 odd population, and maybe the same number in sheep. Why did Britain go to war? It was a war they can't afford to lose. They went to war with Argentina over an island which has no economy at all for 2,500 people. And their reason for doing that was citing United Nations resolution. I can't remember the number, I think it was 501. And that resolution states that it's the right of a people in a colony to exercise self-determination. They can choose to remain with Britain or choose to go with Argentina. They chose, obviously because they were British, they chose to stay as a colony. So irrespective of Argentina's claims of sovereignty, irrespective of any of the legal arguments over the Falklands, they went to war and won. And that success really pushed Margaret Thatcher's popularity, who was then Prime Minister of England, to new heights. And at that time, she was confronted with what I said earlier, the Hong Kong lease problem. She then took the matter, because it's also another colony now, this time it's not 2,500 people. At that time we were talking about 6.5 million people. The number 3 financial center in the world. Right? We were talking about that future. So Margaret Thatcher decided to take a lead in negotiations. And in 1982, she went to Beijing. And she met Deng Xiaoping at the Great Hall of the People. And she was very hawkish. She wanted to ask China to extend the lease. And she said that's what the people of Hong Kong desires. And she said, it's unimaginable that a place which is really a platform of capitalism, of international finance, can be turned over to a regime which barely 6 years earlier have come out of a cultural revolution. You have to remember China at that time in that light, not China today. And she made very strong arguments. But of course, these arguments were completely rejected. The meeting ended, should we say diplomatically, unsuccessfully for either side. She left the Great Hall of the People, and there's one of the famous pictures. As she walked out of the Great Hall of the People, she fell down the steps. But what happened was even worse. The Hong Kong dollar fell that day to a critically low figure, to about 10 US dollars to the dollar in one day. Confidence in Hong Kong was immediately and traumatically undermined. When people were still happily ticking on in this financial center where everything you touch, you make money. Whether it's real estate, whether it's trading on the stock market, the economy was buoyant. And then we had the Hong Kong government just mentioning in a very low key something about the lease coming up. Next thing you have Margaret Thatcher going there. And next thing was the negotiations broke down. But there was another important event in 1982. In 1982, sorry, in 1982, before Margaret Thatcher went to Beijing, Deng Xiaoping and his advisors, fellow members of the Standing Committee in the Politburo, agreed that there is going to be a formula that will be of strategic effect in reunifying the country. They're not just thinking of Hong Kong. They're thinking of Hong Kong, Macau, and Taiwan. One formula. that can be applied in all three situations to result in the complete restoration of the integrity of Chinese sovereign territory. And the formula was to accommodate any other system, doesn't have to be capitalist, any other system other than the communist system of the mainland in the fabric of China itself by means of an amendment to the Constitution of China. The major revision to the Chinese Constitution was in 1982. And an article now known as Article 31 was inserted in the Constitution, which allows the National People's Congress to establish special administrative regions in China. And the systems to be practiced in that region is to be stipulated by the MPC. But if you look at the preamble to the Chinese Constitution, it says the only system that China and all of China must abide by is the socialist system with the Communist Party of China leading that system. So this is, a lot of people didn't pick it up. Or people at that time picked up the new liberalization of the economy by Deng Xiaoping, the going away from the central planning economies, the first days of the opening up of the so-called socialist economy with Chinese characteristics, i.e. a market economy. And at the same time, a lot of people didn't realize that the core group of the party have made another decision that they will allow other systems, including capitalist systems, to exist in the country. And that policy is based on a consensus that the reunification of China is of paramount priority. That hasn't changed. Paramount in the sense that a military determination is also an available option to show the determination that the central leadership had. Therefore, a lot of people thought that one country, two systems was a result of negotiations between the British and Chinese governments in 1984 when the joint declaration was signed. That is not so. One country, two systems was already a concept decided upon before those negotiations started, but at that time the principal target was Taiwan. But as events turned out, the matter was brought up by the British towards the end of 1982, with Margaret Thatcher going to Beijing. Then in 1983, negotiations started properly with two teams, British team and the Chinese team, meeting regularly. And now I'll just mention another matter which a lot of people ignore. That is the diplomatic discussions, although took the form of discussions to reach an agreement which will be encapsulated in a treaty, didn't start on that footing, because the British government has always wanted to negotiate on the basis of the treaties of Nanjing and Beijing. The Chinese government says that's a non-starter. Those are unequal treaties. I ignore them. Sovereignty has always been mine. I wasn't able to exercise it because you had physical control of the territory. So in law, you have been in what we lawyers call in adverse possession of these properties. I'm still the lawful, sovereign power over these properties. Therefore, the formula was that whatever that was agreed in the end would not be called a treaty. Both sides will make a declaration at the same time. But as it turned out, they will say the same things. They will echo each other. So that's why it's called a joint declaration. Now, you may remember there's another colony. Britain has a lot of colonies in those days. Another colony called Rhodesia in Africa, which went for UDI. UDI being unilateral declaration of independence. In this case, it's a joint declaration of resumption of sovereignty. The negotiations continued throughout 1983. The British, who are very experienced and adept negotiators, they have, they thought, a stronger hand in diplomacy. Had their work cut out for them, because at the end of the day, to cut a long story short, they weren't able to achieve anything that they started off with. All the options they had on their agenda, extension of the lease, some form of joint control, all sorts of options. In the end, it was one country, two systems. Because our one country, two systems answers the concerns the British government had, which is, we don't want communism for Hong Kong. So Deng Xiaoping saying you won't get communism. A completely separate system, which you have now, which will continue intact. So the British finally said that, all right, we'll buy that, but we don't think you have much credibility in this. Right? You just came out of a cultural revolution. Your party controls the government. Although now you have a constitution, which you now reactivate because literally the constitution was not enforced during the Cultural Revolution. Right? You now have the National People's Congress in regular meetings, so and you now have organs of state, the State Council. What guarantees do we have that you will honor this? What about having agreed to hand it over to you, you then make changes to Hong Kong and will forever be locked into argument when I say you've changed one aspect of Hong Kong society and you say, oh no, I didn't change that. We don't want complications to develop over this. So the British side and the Chinese side finally agreed that a scientific approach will be adopted, that they will. At that time, the phrase was a snapshot of Hong Kong in 1984. You take a picture, you get out your Kodak Instamatic, you take a picture of Hong Kong in 1984, and you say that is the definitive aspect which will not change for 50 years. So what you did then was to break Hong Kong society down to building blocks, and in a systemic way. So you take out the legal system of Hong Kong, and the Chinese government has to declare a specific policy, what's called a basic policy, and that's where the word basic law comes from, basic policy. A basic policy which is so basic it will not be changed. And the policy, for example, on the legal system is basically the whole of it will continue, common law. But there are always aspects that you need to calibrate, because although the whole of it will continue, you can't allow the final Court of Appeal to be the Privy Council in the House of Lords in England. So that has to change. You have a Court of Final Appeal in Hong Kong. So with the adjustments that are necessary, right, in the resumption of sovereignty, basic policies were declared. Legal system, monetary system, tax system, right, transport system, social welfare, everything defined, basic policies. And in 1984, about 12 to 13 major basic policies were agreed, and there was, under Annex 1 of the Joint Declaration, an elaboration of the basic policies, further elaboration by the Central People's Government. But that didn't stop in 1984. You couldn't possibly have covered everything in just a few months. What they did was they set up a joint liaison group called the JLG, and that went on after 1984, right up to the year 2000. It went beyond the handover before it finished its work on agreeing on everything. And then on the 26th of September 1984, the Joint Declaration was signed, 23 years ago today. Okay. And the first peculiar thing, or should I say unusual feature of this, and I use the word loosely, this treaty, is that normally when you sign a treaty, that's the end of it. The contracting states, Britain and China, right, having signed it, will simply then go away and see that both sides will honor it. The people of Hong Kong have no say in it. And whether China obeys and complies with the treaty, the Hong Kong people can't take it to task. So the British government then made another stipulation that not only will these basic policies under the Joint Declaration be agreed to and set out, those have to be enacted in a law by the National People's Congress in total and enacted as a nationwide law, not just a law for Hong Kong, for the whole of China. Every province, autonomous region, special city will all have to comply with this law. And that is a feature which is unusual because that makes the agreements in the treaty, as we lawyers say, justiciable. That means you can take the government to court. Some of you who know about human rights, international covenants, will know that international covenants, if ratified by any country, is useless to the people of that country unless it is enacted in the Bill of Rights as a law. Then you can take your own government to court for any breaches. But this is unusual for a treaty, right? And that's why, if you look at the Joint Declaration, the most important clause is this, that, and I'm sorry that the Hong Kong Trade Office haven't made this available to you. It actually is in ready supply. For those interested, I think if you leave your name with them before you leave today, we'll make sure you get a copy of the Joint Declaration. But if you look at the Joint Declaration, and if you look at the last clause of Article 3, which contains all the basic policies, it says, the above stated basic policies of the PRC regarding Hong Kong and the elaboration of them in Annex 1 to this Joint Declaration will be stipulated in a basic law of the Hong Kong SAR of the PRC by the National People's Congress of the PRC, and they will remain unchanged for 50 years. So in this clause is the first unusual feature of a treaty, that it requires the terms of the treaty to be enacted into a national law to make it justiciable, and also to stipulate that that law cannot be changed for 50 years. Now, why do I say that's unusual, apart from the fact that there's a treaty? Because the Central People's Government of China is a unitary state. most common law jurisdictions loosely refer to their political system as separation of powers. And that's used loosely because when you talk about separation of powers, you're really talking about an independent judiciary, because very rarely is there a clear separation between the legislative and the executive. I mean, if you take the parliamentary system of government in England, here, Japan, right? It's the legislature that forms the government. Parliament forms the government, whoever is the party with the most majority. So in England, you only vote for an MP. You don't get to vote for your prime minister. In America, it's closer. You get to vote for your president, you get to vote for your senator, you get to vote for your congressman, you sometimes in certain states get to vote for your judge. Right. But anyway, the point being made is that in China, it's a unitary state. It's the opposite. All power is vested in the National People's Congress. So in a way, you can say it's a most extreme model of parliamentary systems in government. A unitary system means that both the judiciary and the executive and the legislative power is all embodied in one entity, and that is the National People's Congress. And they establish, in Chinese expression, 一府兩院, that means one government and two yuan, which means like the Supreme Court. It's the Supreme People's Court and the Supreme People's Procuratorate. Right? So these are the three organs in the Chinese structure. Right? One government, which is the State Council. Right? And then you have the Supreme People's Procuratorate and the Supreme People's Court. And every year at the National People's Congress, these three organs will make their work report to the MPC. Right? So the MPC it creates these three organs of government and exercise control over them. So for example, any laws in China, and laws in China are drafted in a different culture. They're drafted by broad brushes, deliberately. So you don't have to keep amending it. Everything is subject to interpretation. And the interpretation of the law could be done administratively by a particular government unit. It could be done in the course of a court case. But the most important interpretation, the most authoritative and definitive interpretation is by the MPC. So that being the setup, it is very unusual for a unitary body like the MPC to restrain its own powers, because it is the only entity that can exercise that power. And in order to exercise it properly and responsibly, you can't curtail it. Because if you curtail it, then who's going to exercise it? And this is now leading on to the second unusual feature about the Joint Declaration, that apart from it being transformed, a treaty, which is the concept, being transformed into a law, the instrument of that concept, the basic law, it also stipulated that the National People's Congress will not touch this law by amending it in contravention of the basic policies. But these are supposed to contain all the basic policies. So unless they are very sort of technical amendments because of things which are changed because of time or situations have adapted, effectively there's no amendment allowed. Now, that's unusual for the MPC. It's the first time that they passed a law which is not freeborn. They're simply told by the Foreign Ministry of the State Council, you have to do it. The second thing is, having passed it, they have to restrain themselves by actually stipulating in the Basic Law in Article 159 that I will not amend it in contravention of the basic policies. And if you read it in conjunction with the Joint Declaration, they won't do it for 50 years. We're now 10 years down the road. So that, I hope, is not too boring a start. That gives you the setting of what now is the Constitution of Hong Kong, the Basic Law. Now, why do I think these things are important to tell people about these things? There's been a lot of controversy in Hong Kong in the last 10 years. You may or may not have read about them. Mainly they involve interpretations of this law by the National People's Congress. And the word in Chinese, interpretation of law, is sikfa. That expression, you may be astounded to know, is like dirty words in the Hong Kong legal circle, sikfa. The only way that the Chinese government can comply with the Joint Declaration is to make sure that the basic law, A, is not changed, and B, is applied to Hong Kong after the handover in terms of every basic policy correctly. The first controversy concerns the right of abode. And this was in the course of the joint liaison group discussions, that before the handover, the British government had one concern which they feel very strongly about. And again, you have to set the historical context that this was back in the days where China is still very much slowly opening up. But we say a quasi-closed society, forget about its economy, which is going through fundamental changes, that a lot of mainland people, and in those days there were a lot of illegal immigration into Hong Kong. Literally, people would swim down the river to get to Hong Kong. That a lot of them will come over once the Chinese government took it over after the 1st of July, 1997. And the social facilities and the structure of society would not be able to accommodate such a huge influx. And they wanted an assurance from the Chinese government that this would not happen. And the Chinese government says, well, what do you propose? Well, we propose you declare a basic policy, right? As to what sort of mainland people. And I emphasize, these are talking about mainland people, not people in Hong Kong. What sort of mainland people are allowed to come to Hong Kong? We want to know. We want to know a clear policy about this. So the Chinese says, okay, agreed, we'll have a basic policy. Now, what would you like me to put in that policy? And the British government says, I'd like you to enact a law that sets out a concept which comes from the British Immigration Act called a right of abode. It's a legal concept. And then you set out legal principles. One parent is a Hong Kong resident, right? Marries a mainland wife, produces a child, maybe in that situation. Okay, says the Chinese. So then the immigration ordinance in Hong Kong was amended to incorporate a right of abode concept, copying the British legislation, but with its own criteria. And a rough calculation at that time showed that maybe we're talking about less than 100,000, a few tens of thousands of people from the mainland may be eligible under that definition. So that was a JLG agreement, it was a basic policy. Then came the handover, and the basic law became the new constitution. And some mainland people who have some connections with Hong Kong people decided that they, especially those, or in fact those who couldn't get in under the existing arrangement, which is the agreed arrangement, decided to challenge the basic law, right? Because they had nothing to lose. Resumption of sovereignty, courts have to deal with the situation, everything is justiciable. And for us lawyers, there was a new industry that started for us called judicial review. Every citizen can judicially review the government on anything. And they took the government to court. It went to the Court of Final Appeal. And the Hong Kong government says, you don't have jurisdiction under the Basic Law. Your power under the Basic Law clearly spells out, is delegated to you under Article 158 by the Central People's Government. And the delegation in Article 158 says very clearly, only matters which are within your autonomy do you have a right of interpreting it, of interpreting this law. And as you know, the matters that are not within Hong Kong's autonomy were defense, foreign affairs, and there are two versions of the third aspect. One version is the relationship between the central government and the special administrative region. The other phraseology, which is in Article 158, are matters which are within the governance or responsibilities of the central government. Let me also remind myself the words I actually use, although I thought I knew it very well, that it's, yeah, I'll just read that to you. The courts of the Hong Kong SAR may also interpret other provisions of this law in adjudicating cases, right? But if those cases concern affairs which are the responsibility of the Central People's Government, or concerning the relationship between the central authorities in the region, then they will have to refer that to the National People's Congress for their interpretation. So matters within their autonomy, and they say, well, we're talking about mainland people coming to Hong Kong. It's nothing to do with Hong Kong government. And as you know, especially at that time, there is very strict demographic control in China as to not just getting out of the country, but moving around the country, moving from the rural area into the city. You need to, register. Forget about even places like economic zones like Shenzhen. You need special application. So the movement of people is a strictly controlled policy of China. And therefore, this is not a matter that concerns the Hong Kong court as to what mainland people are allowed to come to Hong Kong. The Hong Kong courts disagreed. The Court of Final Appeal disagreed with that. So the Hong Kong government then made its second argument. Well, if you insist on interpreting, then at least you have to interpret as is the canons of interpretation in common law jurisdictions by interpreting in accordance with the legislative intent. And the legislative intent, in this case, is the JLG agreement, basic policy. So the Chief Justice, Mr. Andrew Lee, said, well, show me that agreement. The Hong Kong government passed up a piece of paper. So what's this? It's the agreement. No, it's not. This says here, Hong Kong Government Information Service. This is just a distribution leaflet that purports to set out what's in the JLG agreement. Well, I can't give you the original. This is, part of the sovereign agreement between the two countries, and they are technically confidential, not to be released for any use. And the judge said, well, if that's your argument, then so be it. And when the judgment came out, the whole of the government's argument went. All this about, right of abode concept, restricted, out. You see it in the judgment, you get on the website, it says, they can't produce the evidence. So we will interpret it in the way we want. And their interpretation was very wide and effectively allows, according to the Hong Kong government's calculation at that time, 1.3 million people are eligible to come. A lot of people think that's an exaggeration at that time. But if you look at the events in the past year, when pregnant mainland mothers coming over to Hong Kong, we're talking about hundreds of thousands coming over. They're not coming over because our doctors are better, right? The Hong Kong Hospital Authority are now charging them 67 to 10,000 Canadian, the equivalent, to have babies. Not cheap. They're coming because of the one-child policy. Right? Because if you have more than one child in the mainland, you can't register that that child doesn't exist. And it's forbidden to exist because none of the facilities, you can't go to school, you can't get any facilities, social, medical, anything. And the way to do it is to make sure that person is not a Chinese citizen. in the sense of a mainland Chinese citizen. So some of them go abroad. If they can afford it, go to America, whatever, they can get in. So that's, I diverge a bit, but that gives you an example of how serious the problem was about 1.3 million people. Anyway, the short of it was that then what really got the MPC upset was that this, therefore, is a breach of the Joint Declaration. They've agreed with the Chinese and the British government. Nothing like 1.3 million people can come. And now, of course, it's an open-ended thing because the courts can, once they've seized jurisdiction, can keep on interpreting it, like the US Supreme Court keeps interpreting the Constitution differently, whether you're pro-abortion, against abortion, whatever. It goes with, the thing becomes a live thing, whereas this is a fixed thing. So they then have to interpret it. They exercise their power. Yours is invalid. Ultra vires. Right? It's clearly beyond your autonomy. The Court of Final Appeal agreed in the end. It issued a clarification, very rare in common law jurisdiction, for a court, not in the course of a case. Right? Because once you deliver judgment in the Court of Final Appeal, you're functus. That's it. Right? You no longer have jurisdiction in that case. They issued a clarification. It's a new precedent to say that they were wrong and the MPC was right. But that caused a lot of controversy because when the MPC interpreted, my friends at the bar, in the Law Society, the fellow lawyers, went out protesting, carrying coffins, death to one country, two systems. Hong Kong's autonomy has died. Right? Chinese government is intervening. They wore black. And I was very upset. I was upset because I don't get upset if people are patriotic, unpatriotic, right-wing, left-wing, but I get upset when people do not exercise intellectual honesty. Why are you telling the people of Hong Kong that an interpretation by Britain, by China, to comply with the Joint Declaration is wrong in law, is unconscionable, and breaks up our autonomy? Well, because courts in the common law system, only the courts can interpret the law. But this is this document came, and I've got it in my, sorry, I'll take it out in a moment. This document is subservient to another document, the Chinese Constitution. This document comes out of the Chinese Constitution, right? Because sovereignty has returned. And the sovereign entity is not of a common law structure. It is of a mainland structure, which the British government accepted because it asked that structure to pass a law, the MPC, to embody all the treaties terms. Point number one. Point number two, that's a killer argument. It's a national law. Even if China is not a unitary state, there is separation of powers, like in America. It would not be the Hong Kong Court of Final Appeal that interprets a national law. It would be the Supreme People's Court, wouldn't it? We're just a district government. How can the California Supreme Court interpret the US Constitution? Only the US Supreme Court can. Your argument is not honest. But the worst thing is that people in Hong Kong are misled to the extent that they took to the streets, believing that the autonomy was undermined deliberately. So both in motivation and in execution, people were misled, deliberately or otherwise. Another example, Article 23. Right. Again, first they are dirty words, these are dirty numbers. Article 23, wow. Right? If you look at our papers today, I don't know if you have the papers today or yesterday, Regina Yip, who's running for Legislative Council in Hong Kong, has apologized for handling Article 23 to the people of Hong Kong. Article 23 deals with national security legislation. Every country, when it was first established, will need certain basic foundations. It will need a law that protects its statehood. Every colony that gained independence from Great Britain The minute they gain independence, they have to enact national security legislation, which protects their territorial integrity, identifies the territorial boundaries, identifies your airspace, identifies the symbols of sovereignty, which is your capital city, which is your national flag, which is your national anthem, and forbids by law any attempt to destroy that by means of treason, sedition, or sexation. But in any country in the world, you only have one set of national security legislation within a country, which makes sense. Obviously, you can't have one behavior amounting to treason in one part of the country and not in another part of the country. So people will simply go and do it in that part of the country which allows it. Hong Kong, let me say, China and Canada, in this particular subject that I'm talking about, shares a common feature. And what is that? That both China and Canada is one country with more than one legal system. In Quebec, you have a completely different legal system. It's a French continental system. It's French language, French culture. You have a high degree of autonomy, so high that if your referendum allows it, you can even go for independence. Right? But do you have national security legislation in Quebec enacted differently from the rest of Canada in accordance with French principles? You don't. You have one set of national security legislation. At that time, I was part of I was actually chairman of the bar's Basic Law Drafting Committee. Right? We were concerned with I'm talking about going back now to the days of the negotiation after the Joint Declaration, as to what details should go into the basic law. I said with my team to the Foreign Office in London, could you try and ask the central government, the Chinese government, not to enact national security legislation in the mainland into Hong Kong, because that's normally what happens when you gain sovereignty. On the 1st of July 1997, national laws, the ones that I've talked about, will come into effect by application, and that is, if you've got the copy in front of you, in Annex 3. Right? In Annex 3 of the Basic Law, it reads, national laws to be applied to the Hong Kong SAR. Right? Then you see, if you look at it very quickly, there are things I'm talking about. The size of its territory, the nationality, the flag, all that. Right? It's all here, Annex 3. That the normal course of events in international law will be that on the resumption of sovereignty, national laws of these type, plus national security laws, will come into force. And the British government said, well, what's your basis of your argument? They're not going to say yes to this. Well, I said, well, one, I said that the laws that are in the mainland will be unpalatable to the people of Hong Kong because they are, at that time, laws such as counter-revolutionary offenses. What do you mean counter-revolution? You know, the eternal struggle of the People's Revolution under the Communist Party doesn't apply to Hong Kong, right? Under the Constitution. Well, it clearly says that. So we came out of a case. Counter-revolutionary offenses must deal with a communist system, a socialist system, because it talks about a revolution. And subversion, crimes of subversion. So what do you mean by subversion? To speak against your government? That's freedom of expression. I can love my country, I can hate my government. Okay? And I said, also I believe that they will give it to us. Why? Says the British government. Because of Taiwan. Right? They're prepared to go the extra mile just to get Taiwan back under the same concept, which they've already declared. And the third point, I said, no harm asking. I went to Britain in 1989 when all these discussions were completed and the first draft came out in '89, was debated in the Houses of Parliament in England, and this passed the MPC in 1990 and was promulgated. I went there and I thanked the Foreign Office when I found out that they said, "You're right, they gave it to us. There's now an article called Article 23. You have the right to enact national security legislation in accordance with common law principles." And here's the icing on the cake. They didn't even impose a time limit on it. You don't have to do it immediately on the 1st of July, 1997. Wow, I said. At that time, to me, that was the most precious clause in the basic law. The right. I challenge you to tell me which part of the world, which country allows a provincial or district government to come up with national security legislation. It's a nightmare for the national security enforcement. And that is why Falun Gong operates in Hong Kong, openly, protected by law, can take the court to judicial review, right? They put their money where their mouth is. They control the sovereignty of Hong Kong, and they're allowing a situation, we're now talking about 10 years down the road, we still don't have national security legislation. Are we really pushing against the edges of the envelope? 500,000 people took to the streets with armbands saying, "Down with Article 23. Down with Article 23, I said. Do you know what you're talking about? And these are people who are fellow Queen's Counsel, prominent lawyers, all now members of the Civic Party. Down with Article 23. I said, you mean down with the government's proposal? Maybe you don't like the government's proposal as to what should be enacted. But if you say down with Article 23, if I were the central government, I would say, sure, have it abolished. And then my national security legislation would be applied to you. So there's another example of a huge argument in Hong Kong, which fills me with anger by the day, because the people of Hong Kong certainly don't realize what they're doing when they march on the streets. They don't realize that down with Article 23 means you lose your right to enact the legislation on your own, and the alternative is to have theirs. And I'd like to sum up, because I'd like to have more time for engagement between you and me. You can ask me questions. To sum up the situation in Hong Kong now, in April or May of this year, we have the 10th anniversary celebrations, a formal ceremony in the Hall of the Great People. And the number 2 in the Politburo, number 1 is, of course, the chairman, President Hu Jintao of the Communist Party. The second is the chairman of the National People's Congress, Hu Bangguo. And he met people from Hong Kong who were sent up there, representatives. And he said publicly on the anniversary, 10th year anniversary, he said, although one country, two systems is working, and we can agree it's working successfully in Hong Kong, people in Hong Kong still haven't got it. Arguing about things like Article 23, like right of abode, like universal suffrage, which is another subject matter I'm happy to engage in another time. That what they don't realize is their approach to one country, two systems is completely distorted. Because to be generous, one might say you can read the Joint Declaration in more than one way, because the Joint Declaration says that apart from defense and foreign affairs, Hong Kong shall enjoy a high degree of autonomy. Right? That's the key words, because that defines our high degree of autonomy. Now, there could be two interpretations to this. One interpretation which the Court of Final Appeal took when it made the first decision on the right of a vote case was this, that that sentence means that apart from those two areas, defense and foreign affairs, then I have absolute autonomy. Right? Because it says, apart from these two, Hong Kong shall have high degree. Wait a minute, Hong Kong shall have high degree of autonomy. Does it say absolute autonomy? So that interpretation is like saying, apart from that chair, or those two chairs in this room, everything in this room belongs to me. Right? That's the exclusionary interpretation. Apart from those two chairs, I don't have to set it up. Everything in this room, in your pockets, belong to me. Right? That's the first interpretation. Second interpretation, which I think is the only interpretation, and what the central government says is the only interpretation, and the British government now agrees with me is the proper interpretation, is that apart from defense and foreign affairs, which is of no concern to you, because it's a national matter where the state of war, for example, exists between China and some other country, the rest, you will have a high degree of autonomy, not absolute autonomy. How high? Well, they've spelled it out. Matters which are acts of state, exercise of sovereign power, for example, appointment of the chief executive. Somebody has to appoint him. You can't appoint him, otherwise you're independent. Right? You're part of China. The central government appoints the chief executive, or not the principal officials. Right? Acts of state. And their tenure. Remember, there was an argument whether our present chief executive, when he succeeded Mr. Tung, who resigned, whether his tenure was 2 years or 5 years. Those of you who followed that particular controversy. Right? The tenure. And the other matter is the most important matter to me. The maintenance and the observance of the basic policies.